When does a seller of real property have a duty to disclose defects? I'm Kristen Martinez-Weiner. I own a law firm in Tampa, Florida, handling real estate litigation, primarily some transactional work, but a lot of the disputes and lawsuits that I handle involve buyers who purchase property, they move in, they're all excited, they've got their moving boxes, and they discover a severe defect. It could be flooding. Here in Florida, a lot of times it is water intrusion, mold, it could be a sinkhole. The options are endless. So today we're going to talk about when does a seller have a duty to disclose these types of things to buyers. A couple of caveats before we start. I am an attorney here in Florida. I'm not licensed anywhere outside of Florida. That means I only know Florida law. So anything that we talk about here on this channel is only going to apply here in Florida. Also, I am an attorney. I'm not your attorney. I don't know the specific facts of your case, so nothing in these videos are intended to be legal advice for you for your particular situation. Now that that's out of the way, let's jump into it. So a seller has a duty to disclose defects only under some very limited circumstances. It is not a seller's job to take a buyer and walk them through the property and point out every little thing that may be wrong. Generally speaking, the burden is on the buyer to do its due diligence to figure out whether this is a property that I want to purchase. Is this a good investment for me? What is the condition of the property, and is that something I'm willing to purchase at this moment in time? So there are 4 key elements that are required before a seller has a legal duty to disclose anything to the buyer. The first one is that the seller has to have actual knowledge of whatever the defect is. It is not constructive knowledge, it's actual knowledge. So if a seller doesn't know about a defect, they're under no duty to disclose it to a buyer. If a seller has had work done on the property by contractors, the contractor may know about the defect, but if the contractor didn't relay that information to the seller and the seller had no reason to know about it, never found out that information, the seller has no duty to disclose that to a buyer. So the first one, which is usually the toughest to prove, is that the seller had actual knowledge of the defect. The second one, which seems obvious, is that the buyer did not have knowledge about the defect. So we could be looking at a situation where all of the other elements are met and a seller would have to disclose a certain defect, but if the buyer somehow knew about it, talked to a neighbor, saw a previous inspection report, something out of the ordinary that the buyer actually knew about it before closing, the buyer has no legal claim regarding that specific defect. So number 1, seller has actual knowledge. Number 2, buyer has no knowledge. Number 3 is that the defect has to be something that is not what the law calls readily observable. So what that means is that if you're walking through the property, it's not something that would be visible to the naked eye. It's not a huge water stain on the ceiling. It's not mold growing and seeping through the drywall. It's something that if you walked through and with your naked eye viewed the entire property, you would not see, it would not jump out at you. This also means that a home inspector likely would not uncover this type of defect. It has to be something hidden that the buyer, using reasonable diligence to discover the condition of the property, could not have found. This also means that it is not something that is part of the public record, because if it's in the public record, the buyer, using diligence, could have found it. So this is a big one that precludes a lot of buyers' potential claims, because had they done their homework and their research, they would have been able to uncover this defect. And the 4th requirement is that the defect has to have a material effect on the value of the property. So if there's a plumbing leak and it costs a buyer $300 to fix it, and we're talking about a $200,000 home, that is not a material effect on the value. If the buyer were to go sell that property as is, they could still probably sell it for the $200,000. So you would have to show a material effect on the overall value of the property. That of course is going to depend, are we talking about a $100,000 property or a $900,000 property? So that is going to differ based on the unique situation, but that is the fourth element. So to recap, seller has to have actual knowledge of the defect. Buyer must not know about the defect must not be readily observable, and finally, the defect must have a material effect on the value of the property. Hope this was helpful. Leave a comment below if you have any topic or legal question that you would like me to speak on. Otherwise, we'll see you next time.